Hi, welcome to another episode of the Just in Time Web Show. I'm really excited to bring to you today Grainne O'Sullivan, and she is our new statewide director for Children's Legal Services. So we're really excited to have her today and talk about some of those topics we've been working with across the state. First of all, though, I have a couple of announcements. We had some recent wonderful news articles come out, and I just wanted to highlight those. We're going to be posting the links for these resources right here on the screen. The first one is Florida moves to manage health care for foster kids. Beginning in May, Florida is creating a special Medicaid plan to closely manage the care of children in foster care. Sunshine Health is covering physical and behavioral health, dental care, and other services with a network of more than 30,000 providers. Care managers will help oversee children's social needs as well as their health. And also, Governor's budget recommendations protect and strengthen Florida's vulnerable children and families. This recommended increase in funding supports child protection, prevention initiatives, and mental health services. So again, we're going to link those articles and the resources for this great information that's just recently come out. Also, we've got some wonderful conferences coming up, and we're going to post the links for that information. The Florida State Foster Adoptive Parent Association is hosting its mini conference in Fort Lauderdale. It's going to be Saturday, March the 15th from 8 a.m. to 3 p.m. at the Calvary Chapel. The deadline to register is March 6th, so go to their website at www.fsfapa.org and take a look at the registration information. There's childcare going to be provided, so it's going to be a wonderful opportunity for you to get education and also network with other foster parents. Also coming up in Daytona Beach, May 28th to 30th, is the Daniel Kids Footsteps to the Future annual foster parent foster care conference. So we are going to post the link for the information on there so you can register, and we hope to see a lot of you attend that as well. So now I'm really excited to introduce to you today Grainne O'Sullivan. Welcome, Grainne.
Thank you so much.
So why don't you tell our viewers a little bit about yourself, and then we'll talk a little bit about some of the initiatives and priorities you have with Children's Legal Services.
Sure. Well, thank you so much for having me. I'm honored to be here today. I'm especially honored to take on this role as the new statewide director for Children's Legal Services. I have a long history in dependency. I've been practicing as an attorney in dependency for the past 14 years. I started with the Attorney General's office in Broward County, and I was a line attorney to a supervising attorney to a regional director here at CLS. So I have a really good background on what we do in dependency and how it affects the day-to-day implementation of what goes on with our cases.
Well, fantastic. Well, we're so thrilled to have you and talk about some of the initiatives. You know, at QPI, we've been working closely with Children's Legal Services, and we've had a lot of issues that foster parents have brought to us. And just kind of maybe we'll take a couple steps back and do a little update on those and then talk about some of your new initiatives. But of course, one of the biggest things that I think foster parents deal with on day-to-day with the children they care for is transitions. And it's something that we've been working closely with Children's Legal Services and the state attorneys to, really put together well-planned and thought-out transitions. So could you tell our viewers across the state a little bit about what's going on with transitions?
Sure. Well, it's actually been quite an opportunity for me. As I've been new to this position, I've had an opportunity to travel around the state, get to meet all of my offices, my local offices and regional offices, get an opportunity to meet with the staff that we have in each of our offices. We have a wonderful staff, and they're so hardworking. And part of our regional reviews, we have actually been reviewing our transitions and how good we do at that process. It's actually one of our metrics that we review for our attorneys when they are being evaluated throughout the year. So what we've done is really spent this past year on determining how well we've transitioned our children. We've really kind of involved our parents, our foster parents, our guardian ad litems, and really worked to create meaningful transition plans. The court has been very receptive to our transition plans, and that has been a huge help and boost to us. We've really seen thoughtful transitions occurring all around the state that involves the foster parents, making sure that the foster parents are brought in early on in the case, that they're invited to our permanency staffings when we're staffing the case to determine what the appropriate goal is, and that they're being heard at the hearings when we have a permanency hearing or any other hearing, any critical juncture where we feel it's important to get that information out. And as attorneys, quite honestly, we want to make sure that we're providing the best evidence to the court. And the way to get the best evidence is really who is that current caretaker for that child, how that child is doing in that home day to day, what are they seeing when the child comes back from visits? Is the child traumatized? Is the child happy? That's critical information that only the foster parents can provide. So I'm very big in supporting our foster parents and making sure that they're involved in our plans.
Okay, that's fantastic. I agree. At a local level here, I can tell you we've heard of huge strides in this area. What would you suggest to the foster parent out there that maybe is new to transition planning, or maybe just hasn't had as good a communication maybe with their case manager related to that transition planning? What would you suggest they do with their attorney or to be able to help be part of that process?
Well, I would absolutely say to reach out to your CLS attorney. We have attorneys in every single circuit, obviously every county, that work on these cases every day. As we have been doing our reviews of each of our regions, we have noticed that either attorneys are sending out letters early on in the case, identifying who they are and that they're assigned to the case, and that with their contact information, so the foster parent can just pick up the phone and absolutely call us. We're very accessible. We're more than happy to hear from you, and we do want you involved. So you can pick up the phone and call us. We're also working so where that contact letter goes in the blue book or the red book, whichever people call it, so that it transitions with the child. So when the foster parent gets that, they have our information right there in the book. They can call us, contact us, write to us, email us. Any way they choose, they'll all be in that contact information.
That's fantastic. Wow, what a huge improvement. Now we actually know who the attorney is that's on our case, right? I love that. That's great. That's fantastic. And definitely I am all for this enhanced communication and foster parents really feeling that they can advocate for the children in their home. And like you said, who better knows and can inform everybody, and so that everybody does help make the best decisions for that child. So that's fantastic.
Absolutely.
Well, you know, Grainne, one of the things that we had talked about that was a little bit of a challenge that I was hoping to hear some updates on is when children are moving, say, into a traditional foster home from the group home setting, or maybe even vice versa. Has some work been done to improve those transitions?
Yeah, that's definitely a challenge, Laura, absolutely. Oftentimes CLS gets involved because there's something that prompts a legal action. We get a status report telling us, updating us for the next court hearing, and that's how CLS gets drawn in. Oftentimes, though, these kind of situations become challenging to us because when you're moving a child from a foster home to a group home or vice versa, that's a licensed placement to a licensed placement. So the court is not typically involved in those cases. So then CLS generally is not involved in those cases. However, we have been very proactive with our CBCs and reaching out to them and saying, hey, if something is happening, whether it's detrimental because we get a 30-day notice because a child needs to be moved for a certain reason, or if we're looking to place a child with their siblings that are in another foster home or group home to kind of solidify that family environment, we're asking that they reach out to us and put us on notice so that we can provide a status. Generally, we do provide a status to the court, updating them when that occurs. And then CLS will be triggered to say, okay, are we working to transition this child appropriately?
Right, make a plan.
Yes.
Sit down and make that plan. That's fantastic. Wonderful. Well, have you seen any increased participation of foster parents in court? And have you seen an increased acceptance? This is one of the other areas that we've been working on for a long time, you know, with the judges and the attorneys really engaging the foster parents in the court process.
I will definitely say that I have, prior to becoming the statewide director, I was the Southeast Regional Director for the Southeast region of the state. And I spoke with Carol Shover about this, and she had told me that she had heard from her foster parents that in my region there was definitely an upswing in the amount of foster parents that were being contacted. So I was so thrilled to hear that. And I will say with transition planning, now the courts it's really the new normal, especially with 409. Florida Statutes 409, 145, which promotes these meaningful transitions. It's really becoming very commonplace that the courts are seeing transition plans being filed, and that foster parents are an absolute part of that. So it's, like I said, the new norm, and it's expected that the foster parents are participating in that process.
That's great news. Yeah. I'm so excited to hear this. Wonderful. Well, one of the other things, and this kind of ties in with transitions, but we're going to kind of segue because I know this is going to probably take a little bit more time of our conversation, has to do with this new intervention statute. And in that statute, for those of you who aren't aware of that language that we're using, has to do with the ability of the biological parent to engage a private adoption agency in the process. So could you maybe explain a little bit about what's going on with that statute of intervention, and kind of let us know how does that fit in for our foster parents, and also the best interest criteria when evaluating. Now we've got maybe a foster parent who's had a child in their home for a length of time and may be considering adopting them versus the interests of the adoption agency.
Right. Certainly has been a topic, a very hot topic of debate. The intervention statute was actually enacted in July of 2012. Since it was enacted, relatively we've seen not a tremendous amount of private adoption entities intervening in our dependency cases. However, there have been some, and of those, we've really used it as an opportunity to learn about some of the barriers, some of the pitfalls and challenges that the statute kind of presents. As you may or may not know, when a private adoption entity intervenes, the way the statute reads now is that they can come in, they intervene, and if the court makes a finding that it is appropriate for that placement to happen, it happens immediately, as the language is right now. Mm-hmm. So CLS has identified a few barriers and a few challenges, and really one of those is the language of that immediacy. We're really looking to change that to transition, so that the thoughts that are contemplated in 409 with transition language would actually be brought into the intervention statute.
Right, because it's actually sort of contradictory to all the work we've been doing if this child is going to get moved from, you know, a relative or a foster home or wherever he may be or may have been for a while, and then have that immediate move. Absolutely. It's just the trauma is the same regardless of the circumstances.
Absolutely. Mm-hmm. So if we can get, we have proposed that legislation to the Florida Senate. They have that language, and we're hopeful that they will enact that this year, and that we will have that as part of our intervention statute. And one of the other sections that you had addressed was the best interest analysis. Mm-hmm. We definitely, as we reviewed it, have found that that best interest analysis is very narrow in scope. And really what CLS has provided as a proposed language was to broaden the best interest language. Right now, it's a very narrowly detailed and defined area. What we're asking is for the trial court to consider expanding that, so that we're taking into consideration the length of time that a child has been in the home that they currently are prior to moving to that pre-adoptive placement. We're asking the court to be able to consider the relationship that they have with their siblings and other family members. Is that going to be harmed by severing that relationship to the pre-adoptive placement? We're also asking the court to consider the depth of the bonding that has occurred with that caregiver that child's currently with. That can be significant, especially when you have a young child that's been in that home for a significant amount of time. And also, if the child is of age, we're asking the court to be able to hear from the child and their expressed wishes. So those are some of the things that we'd like to apply to the best interest standard for the intervention statute.
Okay. Now, has there been a change, like with this intervention statute? I have heard that some of the judges are notifying the biological parent, like early on in the case, that they do have this right to basically place the child with the private adoption agency. And I just wanted to get your thoughts about that and how that process fits in with the foster parents and their, let's just say, their ability to potentially adopt the child.
Right. It is the law right now that the courts are required, the trial court is required to provide the parents with notice and opportunity prior to the TPR filing. So prior to the CLS filing a petition to terminate the parent's rights, they are required to hear from the judge that they have the opportunity to go out and to have a private adoption agency intervene. So that when we do that, that's why it's so important with this intervention language, that we're really spelling out all the things that are required in it, that we would like to see in it, so that foster parents have that ability when they're making those decisions.
And if a foster parent is interested, let's say, in the adoption, and the parent has also engaged the private adoption agency, and they would like to help in putting together some of this information for the judge. I mean, ultimately, this is up to the judge, and the judge is going to be faced with potentially multiple adoptive opportunities, right? And all of them are going to have a home study done, and then the judge has to determine which is the best for the child, I would think, in the long run, right? So if the foster parent, what could they do to basically, I guess, help all the parties to know the information to help them make the best determination for this child?
Well, I think that it's critical that the foster parents attend the court hearings. That's where everything occurs. I've participated in many permanency staffings, and I have found personally, as an attorney, when I'm participating in those, that the foster parents' information that they bring to those staffings is crucial. It oftentimes can weigh the decision of that committee on what's going to happen for that child. So I would really encourage you to participate with the staffings, come to court, participate in the court hearings, because there's a lot of weight placed on what the foster parents have to say. So if they're interested in adopting that child, they need to make that known. And they will certainly be one that's considered absolutely in this process.
Okay, fantastic. What about the decision-making process sometimes where you have, a relative versus a foster parent possibly being able to adopt the child? Is there any new trends in those decisions and what judges are taking into consideration for that?
I think with a lot of the trauma-informed care trainings that we've been to recently, Dr. Neil Boris and others, we've really seen that a child is traumatized by several placement changes. We really need to get it right early on. I always encourage family and relatives early on to be identified. So when we're removing that child, we want to know, has a diligent search been done? Have we exhausted all of our efforts to locate relatives? Because we are only inflicting more trauma on a child when we place a child in a foster home and they've bonded, they've spent a year or 2 years. In a very young child's life, that's a tremendous amount of time. So if they've bonded to that caregiver, that's really going to be a priority for the court. And the courts are realizing that with more education on trauma-informed care. It's difficult when you have a relative coming out of the woodwork at the 11th hour saying that they're now interested. It's kind of, where have they been? Why haven't they been involved? Is it our fault? Have we as a child welfare agency not reached out to those people earlier on? So I'm really, really part of, as a statewide director, part of my focus is 3 months. We at CLS need to be involved in those 3-month staffing, because at that juncture we are able to steer that staffing. Have we made all efforts to locate relatives? Have we done diligent searches? Have we identified all fathers in these cases? Because that's a whole
other thing, exactly.
Right. But there's a whole list of paternal relatives that opens up. So if we have not identified the paternity of this child, we're also slowing that process down. So going forward this year, it's a huge priority of mine that we are really actively engaged within those first 1, 2, 3 months of a case.
I'm so happy to hear you saying this, because I think for most foster families, I think the frustration, like you said, is that they've been in the home so long. I think early on, of course, foster parents go into this knowing our goal is to help reunification process. It's when you've had that child in your home, 12, 18, 24 months, and it's going towards adoption, you have that attachment, you don't want to re-traumatize the child, and then like you said, all of a sudden there's a relative that wants the child. And I think for the child's trauma, like you said, and as well for foster parents, it's something that we could do better, like we say, in, like you said, identifying these parties earlier, engaging them in the process earlier. And you even brought to my mind, maybe even when we start out and we're having co-parenting relationships early on, maybe foster parents can even engage in a little bit of those conversations with
absolutely.
the biological parents, like, well, would there ever be another relative who would consider, just
absolutely.
kind of,
Absolutely.
You have to do it the right way, because you don't want to make it look like you're not going to get your child back, because we like to encourage them and say, when you get your child back, not if, using that very encouraging language. But I think on the same token, you can also be learning more about that family unit.
Oh, absolutely. You bring up a good point, because actually one of the areas that I was practicing in the Southeast region, the CBC does this wonderful thing where they have a 3-day conference. So once that child is removed from the home and placed into a foster parent's home, they do a 3-day meeting. We try typically within 72 hours to have a meeting between the foster parent and the mother or father to engage that relationship, because oftentimes it becomes a us versus them kind of mentality, and you're natural enemies. The parents see you as somebody that's taken the child away from me. And those kind of barriers need to be broken down, because when there isn't communication, that's when those barriers exist.
Absolutely.
So opening up that communication very early on, it's as simple as, asking what is your child's favorite food, engaging the parents and asking them, is there a picture of you would like me to have for the child to have in my home? What do they like to do? What's their bedtime routine? Things like that. So we engage and we encourage that communication early on, so that there's that co-parenting is happening.
Exactly, and with the focus being on the child, because I can't take care of your child when I don't know about your child.
Right.
And I always like to think, if my child were going to go live with somebody else, what would I be doing? I'd be writing this long list.
Yes.
He likes this, he doesn't like this, he's
Right.
allergic to this, and I think that is a natural way to change the focus, like you said, and not get into that he against she, or us
Right.
against them mentality.
Right.
That it's really, we're all here for one thing,
Right.
and that's for this child.
Absolutely.
To be able
Absolutely.
to better parent, and also to help that child hopefully get home to those parents.
Yes.
So.
And part of that also, what I was thinking before when we were talking about those 3-month staffings and staffing them early on, oftentimes, to really no fault of anybody's, there's a delay because of an ICPC, the Interstate Compact Act, where we might have relatives that are out of place. That generally takes some time, and there's a lot of bureaucracy behind that and red tape, and we're trying to push through that. So when that is identified early on, we can pick up the phone and call Tallahassee. We have people within the ICPC world that can help us expedite that. Certain times, especially why it's so important for legal, is because under the statute, there are certain parameters where a child would qualify for an expedited ICPC. Cases where a child is under age of 4, or a child has spent a substantial period of time with that prior caregiver out of state, that will qualify for an expedited ICPC. So instead of several months, it would only take several weeks. And again, why it's so important to be very proactive on the front end of these cases.
We did a web show. We just did a web show on ICPCs, and we have learned a lot. And like you said, it can be months. Some of the other states, we learned, actually require even a relative to go through foster parent training classes to take placement of a relative.
Yes, they sure do.
And some of the states aren't quite as integrated with technology, and so some of them, so the earlier you start the process, absolutely better. And hopefully, if the families can understand that, like you said, at that early meeting, they're going to be able to start working those things out.
That's
and,
right.
Get on the fast track, right?
And once we've identified
fast track.
Yes, but once we've identified those families out of home that may be interested in that placement, we can even start slowly that transition process, them coming down to visit with the child, start that bonding, start that familiarity. So it's so critical. I always say my mantra to attorneys is that what takes you a few minutes on the front end of doing will save you months on the back end. So it's so critically important.
Absolutely. I couldn't agree with you more. That's so true.
Yeah.
Well, do you have any priorities or initiatives that you'd like to share with the foster parents that you're kind of looking forward to taking on this new position?
Oh my gosh, I'm just, like I said before, I'm so incredibly honored to take on this position, and I have very big shoes to fill. I always tell Mary, I give her a call and I say, hey, this is what's going on, what do you think? So I still engage her in some of my conversations. I think going forward that I would like to see personally the level of advocacy by our attorneys increased. I think that we have phenomenal, hardworking attorneys, and I want to see them to be performing ultimately at the highest level, so that when we have attorneys that are engaged and that are working hard and that are really sound on their legal advocacy, we're going to have better outcomes overall. So that's a huge priority of mine. And also, like I said, engaging very early. And as for the foster parents, like I said before, they are just critical. They provide such information that nobody else can provide, quite honestly. You know, a caseworker has a certain amount of cases, they're working with a certain amount of children, and they don't have the attention to detail, not that they don't have the attention to detail, but that they are not with that child 24/7. So what that foster parent can provide to us as attorneys when we are eliciting that information at an evidentiary hearing, at a permanency hearing, at a trial, though it's critical and it's crucial for us. So I've always encouraged our attorneys to reach out and to be involved with the foster parents early on in the case.
Okay, yeah. Fantastic. Well, we have a lot of good things to expect, as usual, from Children's Legal Services, and we're really excited that you're taking the reins there. And for all of you, you know, I can't emphasize this enough, that I think it's our role to advocate for children and absolutely to participate as much as we can and to share all that information, because they're not going to know if we don't tell them, and who better to tell them than the people that are dealing with the children every single day. Well, you know, last year really was the year for legislation changes. What do you think as far as the normalcy legislation? You know, is there anything that we can expect to be different and foster parents can expect as far as working with their attorneys related to that law?
Yeah, well, I think really taking into consideration the legislative change and the language of the prudent parent standard, we trust our foster parents to be prudent parents. So things that you would normally do with your child, you should continue to do. I don't think that, you know, it is normal necessarily to come to court and get a court order for certain things that a foster parent would do generally with their own child. There has been some discussion around travel in and out of state. I think if you're providing notice, especially in state, if you're providing notice to your CBC that you'll be traveling. I've seen recently what's occurred, maybe a foster parent has a wedding or a funeral that they need to travel to, especially something like a funeral that occurs on short notice. Providing that notice to the CBC that they'll be out of town for a few days and that where they'll be, how to contact them, and when they will be back. And just certain things that a prudent parent would do when they're deciding what they're going to do for the week for their child, for vacation with their child. And we encourage that. We don't want to stifle it down with having to get court orders for everything.
Good. I think that's wonderful, and it definitely frees up the foster parents to allow these children to lead much more normal lives and not to feel like they have to go through the red tape and wait for court orders for everything.
Absolutely.
So that's fantastic. The other new big one, extended foster care.
Yes.
What can foster parents expect related to that legislation and the courts?
Yes, that's a huge one. Well, extended foster care, really the difference between independent living and extending jurisdiction, what we had previously was the court would extend jurisdiction to a child's 19th birthday if it was for some specific reason. Now with extended foster care, the child can opt to, we're automatically an opt-in state. So the child is opted into extended foster care, which means that they can stay in the system for several more years. And that is a big issue of debate right now, and what we're doing with those children and what that means for foster parents. With opting, a child would have to opt out if they did not want to stay in extended foster care. So, I mean, it's a great statute. It gives our children an opportunity to continue to have that security and sanctity of a home and a stable environment. But there are certain challenges that it meets, and I would encourage the foster parents to reach out to your CLS attorney, because what we do have in every single one of our circuits is an independent living champion, and that's an attorney that is specifically there for those children that are older and that are aging out and that are going to opt in to stay in extended foster care, they are champions of independent living. They know very much, they're subject matter experts when it comes to knowing the extended foster care language and what a child's needs and wants are, and each circuit has one. So you can reach out to your attorney that you may have assigned to your case, and they can direct you to the independent living champion in that circuit.
Okay, fantastic.
Yeah.
Would that champion be carrying all those cases, or they would just kind of be overseeing those cases?
Depending on the caseload. Right now, we're not sure how many children it's going to be.
Right.
So as we're learning more, some circuits envision that they may be carrying those cases. Some right now are the liaison for all the attorneys in the office, but each office has one. So whether they're carrying the case or they're the liaison for the attorney that has the case, you can get all that information from that IL champion attorney.
Okay, fantastic. And how frequently would a foster parent expect to have to go to court with their child once they're at that stage? I would be assuming in a lot of those cases, since they're over 18, it's not a reunification process at this point. It's just services and continuing in the system. So would it be just like a 6-month judicial review?
Generally a 6-month judicial review.
Okay.
It's really at the want of the child. If the child needs or expresses that they want something, they can come and motion to the court. But generally a 6-month review. It's not very
more frequent than that. I don't think they need it more frequent than that.
No.
They'll be like, "Why are you on my case?"
Exactly.
you know that demographic, right?
Exactly.
So I have to go to court again. All right. Well, thank you so much. This has been wonderful, and we are just so excited that you're in this position, and we'll be excited to see all these new things coming up from Children's Legal Services, and then continuing with our initiatives here at QPI on all these things we're looking to do to just make things better for the kids in our care. So just a few wrapping comments. Thank you so much for joining us today and participating in our web show. And we just want to remind you that we are here for you. This show is to bring you information to make your journey easier and better and to keep you informed. We're always looking for your thoughts, comments, suggestions. So please email us those at qpiflorida@usf.edu. You'll see it across the screen. Or you can always go to our Facebook page. You can search Just in Time Training on the toolbar. And I would love for somebody to send me a question they'd like to see answered on a future episode. So send in a question and we'll make sure we answer it for you. So thanks again for joining us, and we'll see you on our next episode.